Every day in the USA, people find themselves in court.
Okay, who is it?
Elena Irvin.
Okay, Elena Urban. Come on up. Here's Munoz.
Thank you. Whoever you are, okay?
Okay, 22-40590 is called. That's you, Elena Irvin. There's a motion to revoke probation on this.
It's not agreed.
There is no agreement?
No, sir. We previously were here with an agreement for 1 year state jail and rejected the offer. Now she's just going unagreed and you're going to make the decision as to what's going to just be jail felony. She re-urges her pleas of true on counts 1 and 2.
All right, the attorney on this one?
What's your name? Mr. Eckert.
This is Elena Irvin. 22-40590. There's a motion to revoke probation that was filed on October 4th, a year ago. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary then, and by the way, raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. In summary, this motion to revoke probation alleges that on January 23rd, 2023, in this court, you were sentenced to 2 years in the state jail, probated for 5 years for the offense of fraudulent use or possession of identifying information. Is that true?
Yes, sir.
Okay. Allegation 1. Back in December. Okay, we already had a hearing on
Yes.
this when she pleaded to 1 and 2.
Yes, sir. She's re-urging her plea of true on 1 and 2. You rejected an offer agreement of 1 year state jail.
All right.
It's unagreed.
Allegation number 1 states you committed the offense of Class B theft on or about May 19th, 2023 in Bell County, Texas. Is that true?
Yes, sir.
And number 2, you committed the offense of accident involving injury and or death out of Dallas County, Texas on June 20th, 2023. Is that true?
Yes, sir.
Are you pleading true, reaffirming your pleas of true that were earlier made on December 2nd of this year? Are you pleading true to those again voluntarily and because those allegations are true?
Yes, sir.
Do you understand that knowing and voluntary plea of true to 1 or more violations of probation, that is enough to grant motions to revoke probation? Your probations can be revoked. I'm sorry, your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true?
Yes, sir.
I think you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. And go ahead.
Judge's state jail felony, which punishment range of 2 years state jail. You previously said you didn't feel like 1 year was enough. So she's accepting responsibility. She's in custody. We're asking the court to consider something less than 2 years, maybe around 15 to 18 months.
Say, what are you going to say? Anything?
That's for 2 years. She's had some revocations before, had some prior sentences.
What about these events that she's pleaded true to while she was on probation? We got a Class B theft. Was on probation for fraudulent use or possession of identifying information, crime of deceit. She commits another crime of deceit in Bell County and then Dallas County in June 20th of last year while on probation. This was an accident involving injury and or death. What was the What happened to the victim in that case?
It's, what happened to the victim? Or
Yeah.
what happened on the
What
case?
was the victim deceased?
No, just injured, right? No,
He died.
I'm sorry, someone was killed. in
He
it.
died,
Yes, sir.
and she was found to be at fault.
Yes, she's serving a TDC sentence on it.
What was the sentence in that?
7 years.
And was there any loss here on this particular
I don't see any restitution ordered on this
case?
case.
We have a judgment and
Actually, let's see.
I don't, restitution not applicable. Okay. All right, here's, according to the administrative this administrative report from the probation office, you were operating a black 2015 Nissan Sentra, which was reported stolen by the Austin Police Department. The Garland Police Department attempted to make a traffic stop. However, you disregarded the emergency lights and verbal commands, and a man identified as Nolan David Timmons Wagner was also found to be an occupant of the vehicle. According to the police department, Wagner jumped out of the car, causing him to sustain a severe brain injury, which led to his death. That's just terrible. Would you agree?
Yes, sir.
Why didn't you stop?
That was my son's father.
It's a human being. That's what's important.
Yeah, I'm dealing with the loss too.
Okay, but why were you, you're dealing with the loss, but you were on this court's probation. You had orders to follow the rules. Why didn't you stop when the police,
Because it was a stolen car. So
how was the car stolen?
my friend stole it.
The person who died?
No, we were, my son's father was gonna help me out with a new phone, clothes. Because I was struggling real bad, some money, and that's why I stole the car to go from Austin to Dallas to meet.
Who stole the car?
Me, my friend.
On my watch, while on my probation supervision, you steal a car and you're on probation for fraudulent use of identifying information, deceit. So you steal a vehicle, 4,000-pound missile, you flee from the police when they're trying to stop you, and somebody dies while you're operating the stolen motor vehicle that you had been responsible for helping to steal. Is that all about right?
Yes, sir.
Oh. I wish that would have not happened, of course, but a lot of wishes don't come true, but we are a product of the choices we all make.
Yes, sir.
And here you are. I feel sorry for the person who died, but you were involved in that. All right. What are you asking for?
Just some consideration off of it, maybe 18 months. State didn't.
State.
Judge, it's too much to ask. I'd recommend the 2 years. She's had revocations, been sent to prison before, so.
What would you like to say?
I apologize for messing up. I'm dealing with the loss too. And I apologize for messing up again.
I just wish an apology could bring back a human's life, but it doesn't work that way. It's your actions and choices that you make, which is what has to be worked on. I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 1 and 2 have been proven true by a preponderance of the evidence or greater. Thus, your probation is hereby revoked. And you are hereby sentenced to confinement in the state jail for 2 years. I really wished you would have done well on probation. You did most poorly. Mr. Dusler is a fine lawyer, but he can't make miracles out of nothing. And he didn't have a lot to work with here by your actions where you committed 2 crimes while on probation. One of which results in the death of a human being, and another is a similar type of offense. Well, both of them are similar types of offenses, and he's taking things that didn't belong to you and being deceitful, and you pay a price. What you're going to have to learn and understand, ma'am, is your actions, your decisions affect other people, just not you. Not just you. You don't live on this planet alone. And this is Exhibit A, a perfect example. People are hurt. You're involved in these actions. You knew better. You were scolded. You were given a second chance. But you have to appreciate other people also are touched by your choices and are affected by your choices, not just you, which means you're going to start having to act more selflessly rather than selfishly, which is the problem. That is all. Do better. You're Edward Lee Brown Jr., sir, and here with Mr. Vasquez, your attorney. Earlier, you entered pleas of guilty to these 3 aggravated robbery cases. I'm correct, as I'm reading this, that this was all the same event, right?
Yes, Your Honor.
And there were 3 victims.
That's correct, Your Honor.
A pre-sentence, and each of these, by the way, are first-degree felony offenses. And a highlighted some stuff. A pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
Yes, Your Honor.
Go ahead.
The defendant's version is incorrect. And they.
Were you present or? Oh, he said he didn't say this?
No, he did say that, but that's not what he meant. What
How
he
do you
meant-
know what he meant?
Because we spoke about it earlier this week.
I mean, you did say this, correct? Hold on. You did say this? I hopped inside the car with my friends, not knowing where we were going. I wasn't aware what was going to happen. We stopped at a house. I got caught up in a robbery. I was there. I couldn't lie and say I wasn't there. It was a dumb mistake. So what you're saying is you really weren't responsible for any of this, even though you pleaded guilty to it. No, that's what this says. Go ahead. We'll pick up from there.
Well, Judge, Mr. Brown pled to and will give you his version of what happened. He is culpable in carrying out 3 aggravated robberies with 2 other people. They were pellet guns, but they were designed to look like real weapons. The victims thought they were real weapons, and he participated in it actively and knowingly. He didn't get caught up in it. It wasn't a bad mistake. It wasn't wrong place at wrong time. He's guilty of it, and realized he should have been more forthcoming when he went to probation. He was trying to evade responsibility and look less culpable. And that's not what he wants to do today. He wants to tell the truth about what happened.
It's about time. You started being truthful. I'm looking at your adult history, theft of property. You were convicted of that. That was deceit. Evading arrest or detention. I mean, that's a form of deceit. And then according to the pre-sentence report, conduct while in child jail custody, the defendant has exhibited a consistent pattern of behavior that has led to numerous disciplinary incidents. The defendant has been involved in the following infractions noted for not complying with orders to return to his bunk during designated times, engaging in conversations and activities in unauthorized areas, showing overt disrespect towards staff involving multiple instructions to return to bunk, which was typical of his behavior throughout the record. Another one, continues to disregard directives, notably refusing to get up from an empty bunk when he was not assigned. Multiple times lying under the covers when instructed otherwise, taking food from trays against the rules, engaging in physical altercations. Cited for inappropriate dress, refusing to adhere to the facility's uniform policy after repeated requests, using offensive language and refusing to follow basic instructions. Disruptive institutional activities like fire code procedures by not complying with orders to rack up and make he's making excessive noise during count times. Defiance was evident when he openly stated he would not follow directives to quiet down or rack up, which led to further disciplinary matters. Disrespect toward a female officer, where he engaged in verbal abuse, continuing to talk loudly after quiet hours, boasted about ineffectiveness of the disciplinary actions against him. And this suggests not only a resistance to authority, but attempts to undermine the discipline by encouraging others and mocking the staff. Wow. I almost lost my breath doing all of that. So you're in custody on my watch. You've committed these 3 crimes, which carry with it up to life imprisonment on each case, and you want to act this way? Okay. All right. It's a cap of 10 years confinement in each of these cases. Go ahead.
Judge, he is 20 years old. And Mr. Brown understands that he'll be on probation. And if something goes wrong, if something goes south, if he messes up anything, he'll be back in your court and he'll be facing a lot more than 10 years. That's my argument.
Okay.
I think he understands that, and if he doesn't, you'll see him soon enough. And you'll remember that he had a cap of 10 years and he'll be facing, I don't know, more than 10. A lot more, could be a lot more than 10.
Your Honor, state believes that it warrants every bit of the 10 years. Believe he's been already given a gift here with just the 10 years on each of these charges. The seriousness of the offense and kind of his lack of taking it serious by acting up in jail and continuing to not follow the rules. Believe that 10 years is appropriate in this case.
What would you like to say, sir?
Speak.
What did she say?
I can speak.
Yes, this is your time. Make the most of it.
Just like to put it out there that I did have some messed up inside of the county and outside of the world. I take responsibility for my actions. I'm not going to say that it was something that I didn't mean to do because I had a conscience that told me not to do it and I still did it anyway. As far as me having bad behavior inside of jail, I do be challenged at moments because I was really challenged a lot of times with officers thinking that it was a game. Wasn't really taking it serious at first. I just asked that I have a chance at life.
Okay. Anything else?
Just, I don't mean to be repetitive, Your Honor,
That's
but I
okay.
think under this court's watch, if under probation would be, I think it would be better than him going to prison for a little bit and being back out. I think it'd be better to deal with him under probation. Can't put a sentence together. I think probation would be more effective than him going to prison a little bit and then being right back out. If he were in his 30s or 40s or something and had a lot of history, I probably wouldn't feel that. But I think because he's youth, he's worth the try.
Anything else?
Nothing further from the state, Your Honor.
All right. The circumstances of this case include that a year ago that the defendant and another were armed with what appeared to be an AK-47, among other firearms, holding several male victims at gunpoint. And police came upon that scene, and then the defendant and another fled. And the defendant was found hiding underneath a storage shed and was arrested. The victim stated that they were accosted by armed men in the backyard, one with a chrome colored revolver, another with an AR style AK-47. And the robbers forced them inside, stealing cash, cell phones, and electronics. And even though it was later determined that the firearms were actually pellet guns, they still fit the definition of a deadly weapon, since a pellet gun is capable of causing death or serious bodily injury. And the Jordan Jones was the other defendant, along with this defendant and
And there was one other.
Mr. Abraham.
Yes, sir. Been around.
And then the defendant, after he pleads, then he is reviewed, does the investigation on the pre-sentence report is prepared by the probation office, and he lies, the probation office, minimizing his responsibility. The defendant has 3 misdemeanor convictions: theft of property, evading arrest or detention, and 2 evading arrests or detention. And two of these occurred before the defendant was involved here in this offense, so they were pending apparently at the time he commits these 3 aggravated robberies, where 3 people were placed in fear of their life and items were stolen from them. Obviously, aggravated robberies are serious, life-threatening events where people who are accosted relate that experience never ceases to haunt them through their life. And this I don't care kind of attitude that you and the other defendant showed just really doesn't help. I mean, you got people's lives in your hands when you don't have the authority to do that. That's our Creator's power, not yours, but you force it on people with threatening behavior. You knew better. And not only did you have prior criminal actions, you're arrested here, and while in custody, I'm reading something a set of events of how you have disobeyed and corrupted the discipline attempts at the jail by your actions. And they set this forth in 1, 2, 3, 4, 5, 6, 7, 8 paragraphs, including the jail incident reports, which are attached to all of this, which this court is just, all you have is absolute refusal to follow rules. And you put people's lives at risk.
Say
So
something.
how do you deal with somebody like that? Well, that's what punishment is all about. In each of these cases, you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 in this case to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. In 24 CR 208, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. And the record shall show that a deadly weapon, namely a pellet gun, was used in the commission of the offense. In the other two, 24 CR 210 and 24 CR 213, there is sufficient evidence there to find you guilty beyond a reasonable doubt in each case. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years in each of those two cases. You shall be ordered to pay restitution in those two cases. What happens is when you are released from custody and serving this 10-year sentence, you're going to be on probation. You foul up on probation, you can be revoked and sentenced to life imprisonment. That's what it's going to take
So,
to get you to follow the rules. Do you understand?
so I had to go to,
You're going to go to prison. When you are released, you're going to be serving these deferred probation orders for 10 years. So we're going to make sure that you are not going to have an inch of wiggle room except to follow the rules like we all follow. In CR 210, restitution is owed to the complainant in the amount of $825. And in 213, while on deferred probation, in that case, restitution is owed in the amount of $10 to that one. So these run concurrently. So you will be serving, when you're released from prison, you will pick up the active deferred or unadjudicated probation. And actually, you're serving, you begin your probation while you're in prison. You foul up in prison, and I believe those can be grounds for a revocation of probation in these other cases.
Do you have those orders, Judge? The deferred orders?
Yeah. You have really made a mess of your life so far. You need to change it.
I want an opportunity to go home and be with my kids. So
Say that again.
I just wanted an opportunity to change around and be with my kids. So
You had kids when you were committing this crime, right?
I ain't one.
You had children, a child or children while you committed this crime, correct? Why didn't you think of them then?
Stupid time.
Well, that's a good analysis of it. Never too late to start acting wisely. This would be a good time to try to turn this into something better. You fill in the restitution.
Yes. Is it?
Yeah, it is.
Oh, it is on there. Okay.
Because once you get out of prison, you see something other than a parole. You need some affirmative actions directly through probation, with the threat over your head that a failure can result in a life, up to a life prison sentence. But you're free falling. You need to catch yourself. Grab the hold of responsibility and make the best of it. Okay, I got signs this. You understand what has happened today, sir? Okay, anything else? That's all. Thank you, Joe.
Thank you.
On Richard Hernandez, we have received, is this the October 29th report?
I believe so, Your Honor. I'm not sure
Okay.
what date it came.
What are we gonna do next? Is he deemed competent?
Yes, I'll let you. He.
Come on.
Has to-
In 22-39083, Mr. Hernandez, I recognize him. Mr. West is here, and we've received a report from Dr. Ed Rapon, who evaluated you. You are deemed competent to proceed to the resolution of your legal matters and is not in need of involuntary psychiatric treatment intervention.
Yes.
I think Mr. Hernandez said that.
Yes.
As well.
Said
So
what?
But you didn't need.
you don't need to go to a
Oh,
hospital.
I don't need no,
Yeah.
your doctor. No, I don't need them. They're not my doctor.
All right. So the
Well,
next thing is,
yes.
what are we gonna do? Hold on. What are we gonna do next?
Your Honor, he indicated to me that he has hired another attorney. I have not received anything.
Until that time, you're the attorney.
But otherwise.
But he
we
can
set it for-
substitute anybody he
Yes,
wants.
yes,
just
so they
depends-
filed substitution. But he has indicated he's not guilty, so we would set it on the trial
Okay.
docket. And if another attorney takes over, then.
Right.
I'll be.
We'll set it for trial, Mr. Hernandez, and you're gonna hire somebody else, you were saying?
Right.
This was- okay.
Already got them. They,
Okay.
all the papers. and
They
stuff,
need to
proof
get the
is,
proper
yes.
papers in
Yes.
and whoever
It
you
is
wish.
from the Capitol building.
Who is it? Do you know?
Ms. Jackson.
Is that who it is?
Yeah,
Mr.
he-
Jackson? Where's he from?
She.
Where's she?
Neely.
Okay, yeah, as long as they're licensed attorney.
I don't know the name, but.
Okay, but we're gonna set it for trial and move this thing so he can move on with his life.
Absolutely.
Okay, anything else? That is all. We're
With Kyle's, Chaz Kyle's, who's that?
reset until what, 1:30? 1:30.
Yes, Your Honor.
Thank you.